Mr. does not get to choose which orders he's going to follow and which orders he's not. And it is completely unfair and disadvantageous. My client keeps taking time off of work. I keep churning a file that I shouldn't have to churn. I have other clients who could use my assistance.
Good afternoon, everybody. It's Judge Schreinert. Hello.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good to see you all. All right, so we're going to go ahead and begin. As we talked about at the last hearing, we've had a request for our Nevada judges to cover the hearing. They've agreed to redact the names, and they will not be naming the children or the parties. And you all had consented to that previously. So they are here. We'll go ahead and get started, and we'll go on the record. This is FB versus. We set today as a status hearing so that we could ensure we were prepared for our settlement conference, which is set, I believe, October 12th from 9 to noon, and then a trial in November. Let the record reflect we are having this hearing remotely. We're all appearing by video. We can see and hear each other. I'm in Washoe County. If I can have appearances, please. Go ahead, Ms. Whitbeck.
Jill Whitbeck on behalf of Petitioner, who is seated with me. We are in Washoe County at the Washoe Legal Services Office.
Thank you. Go ahead, Mr. Davies.
Good afternoon, Your Honor. Richard Davies here on behalf of Mr. President in my office here in Washoe County.
All right, thank you. If I can have Ms. and Mr. raise your right hands to be sworn in, please.
Do you and each of you solemnly swear or affirm that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you all. All right, so my list to cover is we have visitation restarted because our last status conference, there had been no visitation. There was also a question about Mr. Any testing for substances as well as counseling and any substance abuse counseling. Then the other question is the procedure of transferring documents, the list that was in the order that was repeated in the order after status hearing, which included the necessity of signing a release so that Ms. Whitbeck could actually have the information of the providers with which she was supposed to get the information from. So we're gonna take turns just like we always do. Ms. Whitbeck, let me hear from you first.
Your Honor, there have been absolutely no changes other than there has been a positive drug test in criminal court by the respondent. He is challenging that finding and the lab results are not back yet. There has been no visitation. It appears the respondent has not reached out to the supervisor who had previously been discussed with the court. She actually had previously provided supervised Zoom visitation way back last year. There was a talking parents message between the parties where respondent indicated that he had a supervisor. The petitioner asked for the information. It was not supplied. The respondent then asked if the information should come through him or his lawyer. The petitioner responded either way. It didn't matter to her. And that was pretty much the end of it. At this point in time, because of the ongoing failure to otherwise comply with orders of this court, we are asking that visitation be moved back to Zoom through the Family Peace Center, as they have renewed their ability to offer that service, and the parties are familiar with the service because they have used it in the past. In regard to the release that the respondent was to have signed, that was provided to counsel on June 23rd. There was communication between counsel thereafter, where Mr. Davies advised that he had provided the release to his client and had also texted in follow-up and had not had a response. I have filed a motion for order to show cause on that issue, and today I still do not have a HIPAA release. That motion was submitted to the court as unopposed just a couple weeks ago. I want to say July 28th. So it is still pending. In regard to the documents that Mr. Davies was going to provide my office, Mr. Davies has communicated with me about that. It appears that perhaps some of his files are closed and he may not have access to some documents. Nonetheless, the only thing that has been provided to me is a substance abuse evaluation that was not done as mandated by the court, but rather done on a voluntary basis with Mr. Davies sending his client for that evaluation. And that evaluation I already had, and that evaluation I believe had been filed in this court previously as an exhibit back coming into the case management conference a while ago. We do know that the respondent has undergone yet another evaluation ordered by the court in his diversion, as part of his diversion program. And we do know that that was done and provided to the court, but we don't have a copy of it. We would assume that Mr. Davies and his client have a copy of it, but we do not. That's where things stand. Nothing has moved forward at all. However, the court should also be aware that the protection order between these parties did expire. And as soon as it expired, the respondent started needling my client through talking parents as well as through direct text messages, insisting that she speak with him to discuss this case and moving forward, which she has declined to do and has explained to him that there is a no contact order in this case and that their communications are to be limited to the use of talking parents. She has no desire to have a discussion of any kind with him other than through talking parents.
All right, thank you. Mr. Davies, let me hear from you.
As far as the visitation is concerned, Your Honor, Mr. just discussed this. I know originally it was set for what agency was originally a 4-year child, and it was, and that has not been available up until I guess apparently now. I think Mr. provided a name of somebody from his church who believes we could be a suitable supervisor. That's my understanding that he's been communicating with Ms. about that. Okay, hang on a second. Let's finish this. Okay. And so I don't know. So as far as the release, I can tell you, Mr. can address that with you. As far as I believe I gave everything to Ms. Whitbeck that I had. I don't think I have any. I think she has everything I have. And I don't think which was that one substance abuse evaluation she had already. That's the only evaluation I have in my files. About this new substance abuse evaluation that Ms. Whitbeck was referring to that the court has, I don't have that. I imagine we can discuss about whether or not it has that or not. One good thing I do have is he did go down to December 24, and this just right in my office about 10 minutes ago. And I do have a drug test dating back to, which will be filed as soon as possible. I assure the court about that. But dating back to June 16th, it's like almost every other day, every day or every other day, which I'm seeing. The only thing positive is for marijuana, which I believe he has a card for. The reference that Ms. Whitbeck has to a positive test is being challenged by Ms. I don't know about that. Did I touch everything? I think I did. So,
are you his attorney in that diversion case, sir?
I don't, I'm not sure what reference we're talking about because in my mind, a diversion case is in district courts through drug court diversion. So I imagine I'm this attorney of record because I've handled several of those matters, but I'm not. If he's in a treatment program or a specialty court program, typically I don't know if I withdrew or not. Typically, we try to make it a matter of practice to withdraw when the cases are resolved. And he goes on to the specialty court. do you have a public defender in your specialty court?
It's
Okay.
please.
Okay, so he has a court-appointed attorney for specialty court. And so I am not privy to that. I mean, I guess I could be privy to it, but it's not routinely being provided to me. Who is it? Roberto Puentes? Who is
I'm
it?
not sure.
You know who your attorney is?
Yeah.
Well, I don't see it.
It's not one person all the time.
He-
So,
yeah,
but I'm not,
that's-
I don't go
Hold
to the
on.
specialty. Let me just finish.
That's,
Okay, I don't go to the specialty, once the client gets sent to the specialty court, which is a drug court or mental health court or some dual diagnosis court. I'm usually not the attorney record anymore. I might be still technically on the paper as attorney record, but things don't get provided to me anymore after that. And usually in those specialty courts, there's a court appointed attorney who manages those things. So I am not getting routine. So the bottom line is I'm not routinely or systematically getting any documents from that court from that.
Okay, thank you. Ms. Whitbeck, I'll just prefer if you wait till I turn back to you, if you don't mind. Thank you. Mr.
Certainly.
Bruno, let me hear from you first about the release that your counsel emailed to you to sign and provide the information. Go ahead.
Yeah, I wasn't sure exactly what the release of information was. I don't mind knowing that I was there, but the intricate details of my counseling, my therapy and all of that, I would rather have that not be public.
Okay, well, it's not public. It's coming into your divorce case, or custody,
Custody.
excuse me, pardon me. Okay, so there's an order that says you are to provide the following documents. And it doesn't say they're to be provided if Mr. Davies has them. It says Mr. and his counsel are ordered to provide court services evaluation, alcohol testing, drug testing for the last 2 years, any P&P evaluations or report or substance abuse evaluations along with recommendations, mental health evaluations, your alternative sentencing reports, and also compliance with how you're doing in those programs, and your updated proof of income. So nowhere in that list does it say I need your counseling notes. Nowhere in that list is saying I need every detail, but these are the written evaluations. And so far we have none of them. And the reason for the release is because this list was already ordered many months ago and no one provided it. So then if you're not going to provide it, then you would sign a release and then Ms. Whitbeck has to do the legwork to get it. So
I did ask the court to send you guys all my counseling, all my drug tests and everything. And they said you have to put an order in to request it directly from them. They can't give it to either counsel. They gave me my drug test results today. I got them this morning and I've asked for a month now for it. But in order to get the counseling and they need you to get an order to them at DAS.
okay, well, I've never heard of that, Mr. I mean, I'm not allowed to go out and get information. I'm the judge. You all have to give me the information. I can certainly make an order that these things are to be provided, but I don't know how more clear the past order can be, quite frankly. Here's the deal. We keep having these status hearings to make sure we're ready for the settlement conference in October and the trial in November. If we don't get information, then we're just kind of stuck. So, and I mean, I'm assuming this is important to you, sir, but I'm not seeing a lot of the importance.
It's been tough, honestly, because it's out of my control. Like with the visitation, 4 of your children went out of business. She's not even facilitating visits anymore. And he worked for her. I've asked repeated times to have his number. I've asked repeated times to have her do visits. And she said, I don't do them anymore. I'm not in business. So then I found someone I even asked over talking parents. I said, you find one, whoever you're comfortable with. I'm not biased with who it is. It could be anybody. I don't care. I just want to see my son. But the reason I didn't say the name to her is because I wanted to tell you guys, right, in open forum, who it was, where I know them from, their phone number. So we're all on the same page.
Okay, well, who is it?
His name is,
And how do you know him?
we go to the same church.
How long have you known him?
3 months, 3.5 months.
And why do you think he'd be a good supervisor?
He has a child of his own. He's 45 years old. He's actually done visitation for his friends before. So he's kind of familiar with the situation. And I mean, it's a neutral third party that would write reports. So I was just trying to find someone that would allow me to facilitate seeing my son.
Okay. And do you have his phone number handy, sir?
Yes, ma'am.
Okay,
It's,
go ahead.
are you ready?
Yep.
Okay.
Thank you. All right. So regarding what you're telling me is the list of things that we've now had for many months as what was being requested. You're saying that you can't get that. Is that what I'm hearing from you, sir?
I've asked several times to have them, DAS, communicate with family court. Every time I go in there, I ask them, please, everything you said, I need my counseling, my drug test, everything emailed to the family court. They say, we cannot facilitate that. You have to tell the judge to, the only thing they said they could give me was my drug test, and I got them today. And I brought them straight to Rich.
All right. The other topic was about testing. How often are you testing in your other case?
Just randomly. I call
Okay.
every day. It's usually 2 to 3 times a week.
Okay. Thank you. And are you currently in any kind of counseling or?
Yes,
program?
I go to mind and body counseling twice a week. I go to therapy once a week. And then the drug and alcohol stuff another time. I go twice a week. Yes, ma'am. My therapist name is Laura Blauenstein.
Did you say Maura or Laura?
Laura. I can give you their information as well if you'd like.
Well,
I signed a release so the court is able to contact them, but I'm not able to give that. I signed a release for the court to be able to receive the information.
okay. So I can't do that. And I thought that was clear. I can't call anybody. I can't say, get me this information. It either has to come from you and your attorney, or you could sign a release that allows Ms. Whitbeck to contact them and get it. I don't quite understand why your counselor, as opposed to every other counselor I've known, couldn't write up a report about Mr. this many
Okay.
times. And, because what I'm looking for is, I started seeing Mr. on this date. Here's the topics we're working on. He's coming religiously. He comes at blah, blah, blah. He's working on this. We're still working on this. I think he should be in treatment for however long, kind of this general idea. That's what I'm looking for.
See, they report that to DAS. So that's kind of where the cluster is, because all of that's reported to my probation. And I'm asking them to share that information with you, because they have access to all my counseling, all my drug tests, everything. They get it all sent to them. I asked them to communicate with you, and I've asked them literally every time I go there. And they tell me I have their email and everything. They tell me I have to bring it up with you, and the courts have to communicate, or else I would have already had it.
Okay. All right, thank you. The request, Mr. and Mr. Davies, is that we'd like a visitation going on that's a sure thing while we're figuring out this other piece. And I can't say I disagree, because, I'm disturbed at how long it's been now that there hasn't been contact or visit. So the request is we start Family Peace Center again. So that's a for sure thing that you're having a video visit. My plan is to have Ms. Whitbeck and Ms. Reach out to Mr. I will tell you, she's not going to agree without reaching out to him, talking to him, maybe meeting him. He's a perfect stranger, so I wouldn't expect her to, but I'm certainly giving them that opportunity. So things could possibly move forward in a more kind of normal fashion than a Zoom visit. But do you want to address Mr. Davies or Mr. know anything about resuming the Family Peace Center, just so we have something happening?
Well, I think we need something, honestly, and I think that's a good idea, Judge. And I can see the frustration on your face, and I so much share that. I know this feels like there's some basic things that could be getting taken care of, but I think let's get the Peace Center going, and Ms. Whitbeck do her due diligence on Mr. He's a viable supervisor. May they get the wheels greased a little bit and get things rolling here. I'm just going to say this for everybody's edification, it's like, I agree with your honor, or I join your honor, and that's it's very routine for a therapist or a counselor to write a one-page report saying, this is where we met, this is where we're going, this is how things are going, what's going on there too. So so I think your therapist can get something specifically for this particular judge. And so that's something I think we can, now that my client's had an opportunity to hear it from you, he can get working on that, and we can start filing some reports with you.
Okay. And I really don't, I haven't heard before about me ordering another court or agency to do that. I don't think I have jurisdiction, to be quite frank. I have jurisdiction over the two of you, and I can order you and your attorneys to do things. So, you know, I'm not sure what they meant, other than our very specific order that's here. So you know, that just may be a dead end, quite frankly. And you know, unless Ms. Whitbeck, you wanted to subpoena the department that has this, and you said it's DA. What did you say the department was? One of you just said it, Mr.
Alternative sentencing?
Yes, DAS.
DAS.
Yes, Department of Alternative Sentencing. I mean, but I have no idea where that would end up. Ms. Whitbeck, let me hear from you on whatever you want to respond to.
Well, first of all, the respondent has at least 4 open and active criminal matters. Mr. Davies is not the defense attorney in all of them, but he is still the attorney of record in the coercion case, which were the events that led to the issuance of the EPO back last late spring, that started all of this and the filing of this custody case. When we were here in June, the respondent had been MIA for more than 60 days, in the wind, not checking talking parents, not posting anything, not reporting to court. He had warrants out for his arrest in 3 different cases. He spent time in jail as a result, which he admitted at the last hearing. He told us under oath that he attended a dual 30-day inpatient rehab program. He brought no documents, and today I have no documents. I have nothing that proves that he was in this program. Whether he supplied something to the other court, I don't know. It's not on the public record, because they ordered him to undergo yet another evaluation after he was released from that supposed and alleged 30-day program. So here we sit now, almost 2 months later. He was ordered to sign a HIPAA release. The court's order was very clear. The release was provided within the time frame allotted, which was 2 days. It was acknowledged as received by his attorney and presented to him. I have an order to show cause pending. Mr. does not get to choose which orders he's going to follow and which orders he's not. And it is completely unfair and disadvantageous. My client keeps taking time off of work. I keep churning a file that I shouldn't have to churn. I have other clients who could use my assistance. I need a HIPAA release, and I need a separate release for each and every provider that Mr. has seen in the last year, for any evaluations, any counseling, any treatment, any rehab. The problem is that a subpoena doesn't necessarily get me that information. Never mind, I don't even know which 30-day rehab he supposedly went to. He's not identified the facility. I couldn't issue a subpoena right now if I wanted to, because I don't know where he was. And most of the time, when it comes to mental health and substance abuse, they're not going to release records on a subpoena alone. They demand a release. I need my release. So ultimately, if there's an OSC hearing set and we have to come back and argue this again, I know there's no due process to deal with it today, but I need a HIPAA release for each and every provider. This is a very easy thing to fix. If Mr. Davies doesn't have the documents and Mr. can't get those documents sent from wherever to me, not sending them to the court. I mean, yes, of course, the court ultimately will need to see them, but I need to see them. And it's pretty obvious he doesn't want me to see what's in those records. Well, we have a child in the middle here, and the ongoing violations of court orders in multiple venues is egregious. So we're heading to trial. I don't have what I need to go to trial. I was supposed to get it within the last 2 months, and I'm still sitting here with nothing. So this needs to stop. He needs to sign the order, or he needs to spend some more time in jail, the HIPAA release.
Thank you, Ms. Whitbeck. And I did see that you had the submitted order to show cause, that it was filed, that was not opposed. So obviously that's in my submit list to rule on. So let me just explain that, Mr. that there's a request for me to find you in contempt of court for not signing the release that was provided to you as per court order. Now, you've told me in this hearing that you got it, so I know you have it, but you hesitated because of the content. And that ship has sailed, sir. We've already discussed the release at the last hearing. We discussed why we need it. And so the order remains that you need to sign it.
I'll sign it right now.
And I will, Mr. Davies, you can file in a notice if there is a signature and it's provided. And then I will still issue an order on the OSC in terms of attorney's fees or any other issues. But sir, you need to sign it, because here's what's going to happen. I'm not going to delay this case. There's a 7-year-old child who needs some permanency, needs some orders. But if we end up at trial without what Ms. Whitbeck's saying she needs, that actually is what you need, Mr. I don't have anything right now to show me that you've been doing everything and working through and doing what you need to do to be safe. I don't. So this is to everyone's advantage. We do not want to delay. So
I'll sign it right now. I'll sign it right now, ma'am. You'll have it today.
Okay, thank you.
And Your Honor, I want to add, it's not enough that he just signs the bottom. I need the names and addresses of all, I need a separate release for each and every provider. He's now identified Mind and Body, Maura Blaustein, the rehab place, the 30-day rehab. I know there was another evaluation done by some other evaluator. I need a separate HIPAA release with the information filled in for each and every provider, name, address, so that I can then send those releases out to each provider. It's not going to do me any good for him to just sign at the bottom a HIPAA release with absolutely no information about where I send it.
I got it, Ms. Whitbeck. So Mr. Davies, I need you to sit with your client after this hearing, make a list of the providers, count them, go make however many copies that is of that release, and have him sign that many copies and put the name of each of those providers at the top. So that may be 5, that may be 10, we know of at least 3. So that way we can just put this issue to bed and move forward and hopefully get some documents. Okay.
We will get that done, Your Honor.
Thank you. All right. I'm going to go through the rest of the order. We're just going to do a short order after hearing today. The court will do the order. I am going to reinstate the Family Peace Center Zoom visits. We'll put the phone number in the order again so that there is something happening on a weekly basis. Then I'm ordering Ms. Whitbeck and Ms. to contact this proposed supervisor and do your due diligence in whatever it takes for you to either say yes or no, and then communicate the same to Mr. Davies, and certainly the parties can talk about it in talking parents. There's to be no contact or communication except talking parents. That's all I need to say. That's it. It's the only way you're going to communicate. At this point, we're not having communication in person. We're not having phone conversations. It's just talking parents, and that's all we're going to do. And it's regarding the children, or the child, excuse me. We have settlement conference October 12th from 9 to noon. We have trial set November 22nd. It's a one-day trial. Counsel, I don't want to keep driving up fees, but I am willing to set one last status hearing in a month to check in if that moves things forward. I've already told you I'm not planning to continue anything, so that's really not the question. I can do it. I looked, I do have 30 minutes on September 13th, but we don't have to, because at this point, frankly, I think everyone's going to comply, because if you don't, you know what I've said. I don't have anything else to base any rulings on. I have to make best interest findings. I need information. Ms. Whitbeck, any thoughts on a status hearing?
It's really whether or not Your Honor thinks it would be fruitful. And perhaps we just reserve that 30 minutes for our OSC hearing, although I know it's hard to do an OSC in 30 minutes. And then we can vacate if I get, but I got to be honest, I am beyond skeptical. And if I had money to wager, I would put it all on non-compliance right now. So at least not full compliance, because I haven't seen full compliance yet.
Well, I'm happy to reserve that spot for you. If you could look at your calendars, I was thinking Monday, September 13th at 11:30. I have a little opening there, and I also have some
That
time.
does not work for me. I apologize.
And I was going to say, I also have some time at the end of the day that day, if that would work better, or if the whole day is not good, that's understandable.
I think we'd say like 4 o'clock.
I could do a 4 or 4:30.
Can we do 4:30? That would work.
Ms. Whitbeck, what's your calendar look like?
I'm available.
All right, and folks, we're kind of back to Zoom. It's trying to not be, but given the Delta variant, we're back to Zoom. So we'll do the order with the Zoom code for the 13th of September at 4:30. And I'm just presuming our Nevada judges will be there, as they've already been granted the request. All right, anything else? Anything else from anyone?
We will get busy, Your Honor.
Nothing
Okay.
further, Your Honor.
Thank you all. Best of luck to you.
Thank you, Your Honor.